Today, the showdown has been looming at the National Assembly of the Republic of Kenya. And a lot of things have been unfolding at the National Assembly, one of them being the conversation about who are the majority and the minority in the National Assembly. But one thing has stood out. The Speaker of the National Assembly, Moses Wetangula, tries to undermine the decision that was made by the parliament. It tries to label the parliament as a body that has no say over, the High Court as a body that has no say over the Parliament of Kenya. The High Court ruled that Azimio la Umoja, as per the voting and as per the election of the year 2022, the majority of the members of parliament that were elected under the Azimio la Umoja umbrella were the majority in parliament were elected under Azimio la Umoja umbrella. And the minority in parliament were those of the Kenya Kwanza. And the High Court declared a status quo ante, which means that the decision made by the Speaker of National Assembly on October 6th, 2022 is thereby relinquished, is thereby quashed, is thereby termed as non-effective. We cannot rely on according to the Constitution of Kenya, we cannot rely on the current basis of affiliation to name who are the majority in parliament. We have to look at what happened on 8th of August 2022 when the election happened and several members of parliament were elected into parliament. Those that were elected under the Azimio la Umoja ticket coalition are supposed to remain under Azimio la Umoja until the 2027 general election. That is when they can go ahead and relinquish themselves of their affiliation to Azimio la Umoja. Are we together? When you look at it in how the Speaker of National Assembly is trying to do, he is trying to diminish or to demean the power of the judiciary. We all know, as Junet Mohammed has made it clear today, that the executive is an institution that is independent in making its own decision. The judiciary is also an institution that is independent, and the High Court falls under the judiciary. Also, the parliament is an institution that is independent. The parliament comprises of the National Assembly and the Senate. Are we together? So once one of these bodies tries to undermine the other, that makes it that we are in a competition, the executive undermining the judiciary and the parliament undermining the judiciary. And that cannot happen in a country that is ruled by a rule of law and the constitution that defines the roles of different bodies in this country. One thing that Speaker Moses Wetangula will do, even if they move to the Court of Appeal, the Court of Appeal will rule in favor of the High Court because the High Court made a sober decision in doing what it did. You know, they want to term it as if even if the parties withdrew from Azimio la Umoja as of today being 2025, a party went ahead to write to the Office of the Registrar of Political Parties to do away with its affiliation and to serve its ties, to remove its ties with Azimio la Umoja, then that party is not part of Azimio la Umoja. We are speaking about the election of August 2022. That is when these votes happened. And after the election, these people were supposed either to take about 6 months before cutting off ties or before writing to the office of the registrar of political parties to be removed from Azimio la Umoja coalition. Now this tells you that by the time that decision was made, Azimio la Umoja should have been the majority. And as of right now, Azimio la Umoja should continue holding let me tell you, one thing with these decisions that are being made, let me give you a clear example. You know, when you look at it, when a firstborn is born in a family and a second is born, then the secondborn becomes rich more than the firstborn. Do you want to tell me that the firstborn loses his birthright of being the firstborn because the secondborn akona pesa kuliko firstborn? No. That is what is happening here. Azimio la Umoja must take its role in parliament. I want to read these out in clear. The National Assembly Speaker Moses Wetangula has insisted that the High Court ruling issued last week, which invalidated the determination of Kenya Kwanza as the majority party in the House, did not directly declare any political entity as the majority. Addressing the House on Tuesday when lawmakers convened to discuss the ramifications of the ruling, Wetangula clarified that the court's decision merely quashed his earlier direction and did not actually declare any side as the majority in parliament. According to Wetangula, it is only the National Assembly Speaker who has the authority to declare who holds the majority in the House. The judgment quashed the direction of the Speaker on the majority and minority. It never declared who is the majority, Wetangula said. It's not the court to declare the majority, it is the Speaker of this House, and you better know that. It is the Speaker of the House to declare the majority. But how should we trust the Speaker who has affiliations with the government and has a conflict of interest when it comes to making this decision? Because the Speaker still holds the role as the party leader of the Ford Kenya party, and he still holds the role as the Speaker of the National Assembly. His party is under the Kenya Kwanza. For him to be able to make sober decisions that he can favor nobody, he has to relinquish himself from holding the position as the Speaker. Either as the Speaker of the National Assembly or as the leader or the party leader of Ford Kenya. To push his point home, Wetangula emphasized that the court's decision simply returned to the situation in parliament to the status quo ante, meaning that the status of the majority party is now to be determined by the House. The upshot of the judgment of the court. In law, we say we go back to the status quo ante. When you go back to the status quo ante, then the House has to make a decision and a finding on who the majority is. The court has not declared any party a majority in this House. Read the judgment carefully. He said, we have gone back to the status quo ante as to who is majority. The Speaker will make a finding. Wetangula further argued MPs to engage with the matter based on the facts and law and not on unverified information. Don't speak from what you are hearing in the air. According to the High Court ruling, Wetangula violated the Constitution by declaring Kenya Kwanza the majority in Parliament. The ruling stemmed from a decision made by the Speaker on 6 October 2022 when 14 members from various parties were reassigned to Kenya Kwanza, tipping the balance in favor of the coalition and enabling it to claim majority status. However, the court found that the Speaker had no justifiable basis for the reassignment and quashed the decision that had declared Kenya Kwanza as the majority. According to the Speaker, Wetangula's determination, Kenya Kwanza had 179 members in the National Assembly, while Azimio la Umoja had 157. However, official documents from the Registrar of Political Parties indicated that as of April 21st, 2022, Azimio comprised of 26 political parties, whereas Kenya Kwanza had only 15. Now, if we are to use the right channels and make the sober decisions that are supposed to be made, then Azimio la Umoja should take that. It is their birthright, as per the current government, to be the majority in parliament. And if that is denied to them, then they should even serve they should even do away with the broad-based government agreement. Because there is no way these people are going to work in favor of Azimio ever again. And Wetangula should leave his position. Subscribe.